Well, good morning, everyone, again, and welcome to the latest in Cornerstone Barristers series of 2022 webinars, and the third in my series for July on licensing the private rented sector. For those of you who joined me for the first two, we've already covered designations and license applications and fees, and today's webinar will focus on licenses and license conditions, understanding the scope of local authority powers. For those of you who don't know me, I am a barrister specialising in public law, local governments and housing at Cornerstone Barristers, and I have a particular specialism in regulation of the private rented sector under the 2004 Act. So this, as you might say, is right up my street. Without further ado, let's see what we can expect from today's webinar. Well, the grant and the administration of licenses under Parts 2 and 3 of the Housing Act 2004 raises various often recurrent legal issues about which I'm often asked to advise, not least of which the first in the list on this slide. So, for example, in a block of commonly controlled flats, what exactly is the Part 3 house that requires a license? As many of you will know, there's been a lot of debate in recent years since the 2017 case of Tuit, in which I was involved, about the scope of the local housing authority's power under Part 3 to license individual flats in a block of commonly controlled flats. And so today we'll take a look at the upper tribunal's recent judgment on that issue, if I may say a typically erudite judgment by upper tribunal Judge Cook. Other issues that commonly arise include, for example, the longevity of a license. So how long does a license remain in force? What happens to a license when the licensing designation expires? And additionally, what power does the local housing authority have to vary or revoke a license? A perennial issue that commonly recurs is the local housing authority's power to include conditions in a license, and many of you who are presently designating or looking to redesignate, redesignate areas as subject to additional or selective licensing will be grappling with this question at the moment. What conditions must the local housing authority include in its licenses? Perhaps more controversially, what can it include? So do the local housing authorities' powers in Parts 2 and 3 differ, and if so, how? We'll take a look at this towards the end of the webinar and consider, for example, what conditions regulating the management of a Part 3 house might include. So in short, the focus of today's webinar will be on license characteristics, their duration, scope, content, etc., and on the local housing authorities' powers when granting and administering licenses. As before in the last two webinars, any views that I express are for educational purposes only and are not advisory. So if you do require advice about any particular issue that arises today or in respect of licensing generally, then please obtain separate legal advice, and I will of course be glad to assist if you would like to instruct me in chambers. Any queries arising from this webinar, you have my email address on that slide. So let's take a look first of all then at licenses. So the first of these slides, as I've called it, concerns temporal considerations. So the time at which a license may be granted, when it comes into force, how long it lasts, etc. For this, and indeed many of the matters that I'll discuss on the next few slides, you need to consult sections 68 and 91 in parts 2 and 3 of the 2004 Act respectively. So by those provisions, a license may be granted before it's required, but cannot come into force until it is required. Now, what does this mean for local housing authorities and landlords? Well, for local housing authorities, it means that they are able to receive, to process and to grant license applications in the minimum 3-month period between a designation being made or confirmed and coming into force, meaning that they're able to manage the workload effectively and avoid an application surge, for example, when the designation is in force. For landlords, importantly, it means that they're able to anticipate the need for a license and protect their position by applying for one before it's required and before they become potentially liable for an offence under Section 72 or Section 95 of the 2004 Act, which we'll be looking in more detail next week on enforcement. As many of you will know, the fact that an application has been duly made, as we discussed last week, and has not been determined provides a defence to any such liability. So there are benefits from that provision for both local housing authorities and landlords alike. As for when a licence is required, you need to take a look at sections 61 and 85, in short, subject to limited statutory exemptions or exceptions. A licence will be required if, for example, under Part 3, a house is a house to which Part 3 applies, for example, because it lies within a selective licensing designation. A license will come into force at the time that is specified in or determined under the license. And in most cases, that will either be the date when the designation comes into force, if the license is granted beforehand, or the date of grant, if the designation is already in force. Now, unless previously determined, because the license holder dies or the license is revoked, the license will remain in force for the period specified or determined in the license. That's provided for explicitly in the Act itself. And they're interesting provisions. Local housing authorities often ask, well, for example, what if the house ceases to be an HMO to which Part 2 applies, or a Part 3 house in that time? And the answer to that question is furnished by sections 68.5 and 91.5. And if you'll bear with me, I'll see if I can pull section 68.5 up for you on the screen. So I hope that you should now be able to see section 68 on your screen, and you'll see subsection 5. So that provides, in short, that the license will remain in force for the period specified in or determined under the license, even if during that period the house subsequently ceases to be a Part 3 house or an HMO to which Part 2 applies. What does that mean? Well, on the face of it, it appears to mean that even if the licensing designation expires, the designation, of course, being prerequisite to a house being a Part 3 house, or an HMO to which Part 2 applies. So even if that designation expires, or the house, for example, becomes owner occupied, the license will remain in force. And one consequence of this was considered in the first tier tribunal case of Iawa, which we'll take a look at a bit later on. So if I just move you back to the slides. So the 2004 Act does put a limit on the length of a license. It must expire no later than 5 years after it was granted, or if it was granted before it was required, no later than 5 years after it comes into force. And in the case of Iawa, to which I referred a moment ago, the council had granted a short-term license that expired, and this was a Newham case, so hello to the Newham officers if you were involved in that case. They granted a short-term license that expired with the designation, and the local housing authority, so rather the license holder, appealed to the first tier tribunal, arguing that the council should have granted a 5-year license, even though the existing designation would have expired before the license did. The first tier tribunal agreed with that argument and actually varied the license to one of 5 years. For various reasons, including some of those we've just discussed. And although the first-tier tribunal's reasoning was respectfully very brief, I'm inclined to think that conclusion was right. It's yet to be tested, however, in any higher court or tribunal of record. So potentially that's an argument that remains to be made and tested and determined in a higher court or tribunal. So other characteristics of a license, other than the temporal characteristics, let's take a look at some of the key characteristics. One of those is the restriction that a license may not relate to more than one HMO, or as the case may be, Part 3 house. One of the corollaries of that under Part 2 is that where there is an HMO within an HMO, such as a self-contained flat HMO within a Section 257 HMO, each of them will require a license. And that much appears clear in respect of Section 257 HMOs at least, as Section 257 subsection 5 makes specific provision. And if you'll bear with me, I'll flick again between the different screens, and I'll pull Section 257 up for you. So, Section 2575 provides, as you'll see, that the fact that this section applies to a converted block of flats with the result that it's a house in multiple occupation under Section 2541E does not affect the status of any flat in the block as a house in multiple occupation. The result, therefore, is that where you have, as I say, where you have a self-contained flat HMO within a Section 257 HMO, each of them will require a license. And arguably, the same result would ensue if there, for example, is a self-contained flat HMO in a converted building HMO, although Section 254 doesn't contain the same provision as we've just seen in Section 257, so that result is yet to be tested or affirmed. As for Part 3, the restriction has, along with the provisions made in Sections 79 and 99 of the 2004 Act, for example, has led to argument about the Part 3 house that requires a license under Part 3. In circumstances where a block of self-contained flats is under common control. So what then, it has been asked, is the licensable Part 3 house? Is it the block? Is it each flat individually, or such a number of those flats as are under common control and contiguous, that is, adjacent in the block, either vertically or horizontally? So debate about that issue ensued for several years following the 2017 case of Tuit that I mentioned at the start, in which Ranjit Bose QC and I acted for the local authority, Waltham Forest, but which settled at the doors of the Divisional Court. Well, the Upper Tribunal has very recently, just last week in fact, considered and determined that issue, in part at least, in the case of Northumberland Mews Limited and Thanet District Council. And those who were online with me for yesterday's hearing in the first-tier tribunal will have heard reference to that particular case. And we'll take a look at that decision in a moment. Before we do so, however, note that a license may not be transferred to another person. So the 2004 Act is clear that a license is not transferable. In other words, it's personal to the person to whom it was granted. But for clarity and completeness, the Upper Tribunal affirmed as much, another Elizabeth Cook judgment, as I understand, in Taylor and Mina Ann Limited. And again, we'll take a look at that case very shortly. But first, let's take a closer look at the recent Northumberland decision. So the essential facts of Northumberland were that, as you'll see on the slide, Northumberland was the freehold owner of a block of self-contained flats. And the local authority, in this case, Thanet District Council, penalised Northumberland under section 249A of the 2004 Act for managing various Part 3 houses, which actually were 5 of the flats in that block, without a licence, contrary to section 95(1). Northumberland appealed to the First Tier Tribunal against the decision to impose those penalties, and in essence it ran exactly the same argument as Mr. Tuitt had run before the Magistrates Court and the Divisional Court back in 2017-2018. And Northumberland argued that it had not committed the offences for which the authority had penalised it, as Thanet was required by the statute under Part 3 to licence the block and not the individual flats. In other words, Northumberland said, where you had a scenario where a block of flats was under common control, the only Part 3 house that could require a licence was the block itself. Well, the First Tier Tribunal disagreed, and it found where material that the plain and ordinary meaning of section 99 of the 2004 Act, which contains the definition of a house for the purposes of Part 3. Bear with me, and I'll pull that up while we're discussing it. The plain and ordinary meaning was that a flat fell within the definition of a house for the purposes of Part 3, and therefore, as a result of that, the local housing authority had a discretion to license them either individually or collectively. It's taken me a while to get to section 99, but there you see on your screen, hopefully, the definition of a house. So in this part, a dwelling means a building or part of a building, and we'll come back to that in a moment, part of a building, occupied or intended to be occupied as a separate dwelling, and a house for the purposes of Part 3 means a building or part of a building consisting of one or more dwellings. So Northumberland appealed to the upper tribunal, as I say, on the grounds that the flats were not Part 3 houses and that the only offence it had committed was in relation to the whole house, in other words, the block. The upper tribunal rejected that argument and endorsed the local authority's construction of sections 79, 90 and 91 of the 2004 Act, having, as Waltham Forest did back in 2017, the benefit of representation by Ranjit Bose QC of these chambers. So if you just bear with me, again, I'll flip between screens, and hopefully I'll be able to do that a little swifter than I did previously, a little more swiftly. So there you have paragraph 41 of the judgment, which is not in fact the tribunal's holding or decision, but actually the argument that was presented by Thanet, which in fact was endorsed by the upper tribunal. So the argument that was endorsed was that that in essence, the essence of Part 3 was flexibility. The Act didn't prescribe whether a block of flats owned by a single freeholder must be subject to one licence or several, and that enables an appropriate response to numerous circumstances, as in the background of the Khan case, where the local authority had 6 flats, I believe, and had licensed 4 of them on a 5-year basis, but 2 of them on a 1-year basis because there were various planning issues, and the flexibility of Part 3 had enabled it to take that approach, not licensing the block, but licensing the flats individually. And to practical requirements, for example, where a landlord wants to appoint different managers for different parts of the building, it continued, or rather it upheld this argument: there cannot be only one right answer to the question, what is the Part 3 house, in a situation involving 2 or more dwellings within a building, nor is there only one possible offence that the landlord of such a building can be charged with. So the local authorities' arguments, and as it had argued into it, prevailed. The consequence is that under Part 3, the local housing authority has a discretion to identify the scope of and to license a Part 3 house as appropriate, according to the circumstances that are before it. And that gives it, as Judge Elizabeth Cook held, the flexibility to be able to adapt and respond to different circumstances. Note that the upper tribunal did not decide, because it didn't have to, whether a local housing authority may issue one license to authorise the occupation of flats that are not contiguous. The argument against that approach is that flats that are not contiguous contiguous cannot logically comprise a part of a building to which the definition of a house in section 99 refers, as we saw a moment ago, and that issue therefore remains to be resolved. So I mentioned that we would come back to the case of Taylor and Mina Ann Limited, a 2019 case, and again an Elizabeth Cook judgment, I think. The essential facts were these: that in July 2016, Taylor took a tenancy at a licensed HMO, but in October 2016, just 3 months later, the HMO changed hands and it was purchased by Mina Ann Limited. Only 7 months later, if my maths is correct, 7 months later, in May 2017, did Mina Ann apply for an HMO license. And in September 2018, that license was granted. Now, Taylor then applied for a rent repayment order for the period from October 2016 all the way through to September 2018. But the first tier tribunal dismissed that application on the premise that the HMO was already licensed because the former owner, their license hadn't expired. Taylor pursued that to the upper tribunal, which upheld the appeal. In a nutshell, it held that as the statute provides, a license is personal and cannot be transferred to another person. Section 68 under Part 2, for example, makes that provision in respect of HMOs. So Mina Ann could not rely on the former owner's license in order to escape liability and had to apply for it out. And the failure to do so amounted to a criminal offence under the 2004 Act. The fact that the former licence had not been revoked and continued in force, something that we will return to a little bit later on, was of no assistance. The application was, however, remitted to the first tier tribunal so that it could determine the relevant payment period. And the eagle-eyed amongst you will have noted, given what I said previously, that Taylor could not have been entitled to a rent repayment order for the full period, October 16 to September 18, because of course by May 2017, Mina Ann had in fact applied for a license, which, as long as that application is duly made, as we discussed last week, provides a defence to liability. So let's take a look at some of the other, perhaps more lesser known characteristics of a license. This concerning the death of a license holder. So a license, and this is not a common occurrence, certainly not in my practice, but a license ceases to be enforced on the death of the license holder. That is expressly provided for in both sections 68 and 91. And I'd note in passing that the existence of that provision in section 68 and 91 rather lends support to the proposition that a license remains in force even if a designation ends before the license expiry date. Why do I say that? Well, it's quite clear in both of those sections that Parliament provided expressly for circumstances in which a license would cease and would cease to be enforced. And it had the opportunity, therefore, and it clearly addressed its minds to when a license should cease, but it didn't legislate, as it would have been very easy for it to do, for a license to expire with the designation under which it was granted. And so, as I say, that rather lends support to the proposition that, that even if a designation expires, then a license will remain in force nonetheless until the date on which it is expressed to expire. However, as you'll see from the slide, for 3 months from the date of the license holder's death, the HMO or house is treated as if on that date a temporary exemption notice had been served, and the license holder's personal representatives may, during that 3-month period, ask the local housing authority to extend the initial 3-month period for a further 3 months. So in a nutshell, there is the facility under the 2004 Act for personal representatives to extend temporary exemption or the effective temporary exemption for up to 6 months, but no more. The local housing authority may, upon such an application, if it chooses to do so, serve on the personal representatives a notice which, for that period, that extra period of 3 months, has the same effect as a temporary, exemption notice. And so, as I say, there's a minimum 3-month period of exemption, maximum 6 months. If the local housing authority decides not to do so, however, it must, and without delay, serve the personal representatives with a notice that informs them of its decision, the reasons for it, rights of appeal, and the period in which an appeal may be made. And as a result, the personal representatives may then appeal to the first-tier tribunal against the decision. And as is usual in such appeals under the 2004 Act, the first-tier tribunal has power to either confirm or reverse the local authority's decision. So, as I say, these provisions provide personal representatives with, if you like, a period of grace in which to either arrange for the property to be licensed or to take steps to ensure that it no longer requires a license under Part 2, or as the case may be, Part 3, for example, by lawfully evicting the occupants for the purposes of a sale with vacant possession. Let's take a look then at the variation of licenses under Parts 2 and 3. And for this, you need to look at the provisions made in sections 69 and 92 of the 2004 Act. And they provide that a local housing authority may vary a license in broadly two circumstances. First of all, with the agreement of the license holder, and secondly, if there has been a change of circumstances since the license was granted. And they are the only two circumstances in which the license may be varied. What does a change of circumstances comprise? Well, it plainly includes, by sections 69 and 92, subsections 1, any discovery of new information that's expressly provided for. And therefore it likely includes, for example, a change that might have to be made to license conditions to reflect changed circumstances. I discussed briefly the circumstances of Waltham Forest and Cairn. So, for example, if in the Cairn case, the local authority had been satisfied that planning arrangements had been planning requirements had been properly complied with, they would then be able to change the condition that related to the planning requirement in the license, and indeed vary the license duration to extend it to the full 5 years. Now, local housing authorities have the power to vary a license on its own initiative, or on an application by the license holder or a relevant person. And relevant persons include those, for example, with an interest in the premises, and they're defined under the 2004 Act. And there is, as you would expect, a procedure for variation, which is prescribed by Schedule 5. I'm not going to go through it in detail, but in short, it includes the service of a notice giving notice of the local authority's proposed intention to vary and what the terms of the variation would be, a period of consultation for the license holder and relevant persons to consider those proposed changes, a provision for the local authority to consider representations made in response to its proposal, and then decisions. Variations made with agreement will take effect when they are made. Otherwise, they take effect at what is termed the operative time as defined in Schedule 5. And broadly speaking, without going into detail, the operative time is defined by reference to when the period for appealing the local authority's decision expires, or if an appeal is made, when that appeal is determined. There are specific provisions which will apply if, upon variation, the local housing authority is considering what maximum number of persons or households should occupy an HMO, or what standards applicable to occupation should apply. And I won't go into those provisions. They provide for the standards to apply that applied at the time that I think the original license was granted. But as I say, I won't go into those in detail because they are rather dry. So from variation through to revocation, and there are, as you'll see in a moment, there are two types of variation: discretionary and mandatory. So local authorities may, and for this you need to look at sections 70 and 93 of the 2004 Act, they may vary a license either with the license, revoke a license either with the local housing authorities, the license holders agreement, or unilaterally if one of several conditions is met. So for the vary in the top line of that slide, please read revoke, and I'll amend that before the slide is sent out. So those circumstances, if it's done with the license holders agreements, there's no need to consider these circumstances. If it's done unilaterally, it can only be done if these circumstances apply. So they are if the license holder or any other person has committed a serious or a repeated breach of license conditions. If the local housing authority no longer considers that the license holder is fit and proper to be the license holder, or considers that the management arrangements at the house or the management of the house is not being carried out by persons who are fit and proper. So if there's a change in circumstances which begs the question whether license holder or manager is fit and proper, there is a power to revoke. If an HMO ceases to be an HMO, to which Part 2 applies, or a house ceases to be a Part 3 house. So just going back to what we were saying about the expiry of licenses, on the face of it, again, this provision supports the proposition that even if the designation expires, the license remains in force. In those circumstances, of course, it would be open to the license holder to say, well, look, the designation has expired, please now revoke the license, or indeed it would be open to the local authority to exercise its discretion to do that. If a license is granted under Part 2 in respect of what was previously a Part 3 house, so for example, a house that was previously let to a single household becomes an HMO, and a license is granted under Part 2 in respect of it. Were the license to expire at the time of the revocation, the local housing authority would, for a particular reason relating to its structure, the structure of the house, refuse to grant a license to the license holder on similar terms. There is a power under these provisions to prescribe more circumstances in which a local housing authority may unilaterally exercise its discretion to revoke, but these have not yet been exercised by either the Secretary of State or by the Welsh Assembly. Again, as with variation, there is a procedure that is prescribed by Schedule 5. It's very similar to the procedure for variation, which includes the service of a notice of proposed revocation, a consultation period, representations, and the local authority's decision. Those of you who impose financial penalties will be broadly familiar with that process because it's by and large replicated in Schedule 13A. Revocations that are made by agreement take effect when they're made. Otherwise, again, they take effect at the operative time, again defined by reference to the expiry of appeal periods or the determination of any appeal that is made. And then, as I say, we come on to the mandatory revocation of licenses. And this time the slide does read revoke rather than variation, rather than vary. So the local housing authority must, and again for this you need to look at sections 70A and 93A, must revoke a license if either a banning order is made against the license holder under the Housing and Planning Act 2016, or a banning order is made against a person who either owns an estate or interest in the house or part of it, or is a lessor or licensor of the house or part of it. So there is an obligation, not a discretion, but an obligation to revoke a license in those circumstances. Again, for the procedure, Schedule 5 provides, but note there is no need for an initial notice or indeed a consultation period because we're not dealing here with a discretion to revoke, but an obligation to do so. However, the notice of the decision to revoke must state when that revocation takes effect. It can't take effect earlier than the end of the period of 7 days, beginning with the date that the notice is served. And as you would expect, there are again rights of appeal in respect of any decision to revoke under these provisions. So that, I hope, gives you some idea of the key characteristics of a license that it may be granted under Part 2 or Part 3 of the 2004 Act. And in the time that's left, I'd like to look at the, if you like, the perennial and more controversial issue of license conditions that must and may be included in such licenses. So, as many of you who are or have grappled or are grappling with the designation of areas as subject to additional and selective licensing will know, a license must, for which see sections 67 and 90, must include certain mandatory conditions. And for those, you need look no further than Schedule 4 to the 2004 Act. And as many of you again will know, they are largely concerned with ensuring that whether the house is an HMO to which Part 2 applies or a house to which Part 3 applies, that HMO or house meets certain minimum health and safety standards in order to mitigate, reduce, remove such risks as there may be to the occupants of that particular property. Note that the conditions that I have set out on this slide are heavily paraphrased. So if you want the detail of the provisions, please take a look at Schedule 4 itself. In fact, while we're looking at this, I'll see if I can bring Schedule 4 up onto the screen for you. So there are certain mandatory conditions that are common to both licenses under Parts 2 and Part 3 of the 2004 Act. And on the screen now, you should see the first of them, which relates to the production annually by the license holder of a gas safety certificate that has been obtained in respect to the property in the previous 12 months. And others, as we scroll through Schedule 4, relates, for example, to keeping electrical appliances and furniture in safe condition. In England, to ensuring that ensuring the working order and safety of electrical installations, ensuring the installation and working order of smoke alarms, In England again, not in Wales, ensuring the installation and working of carbon monoxide alarms, and supplying occupiers with written tenancy or license agreements. And as you see on your screen, we're just flicking through some of these provisions. They are, as I say on my slide, heavily paraphrased. So for the real nuts and bolts of this, take a more detailed look at Schedule 4. So as I say, those mandatory conditions, whether in relation to Part 2 or Part 3 of the 2004 Act, are concerned primarily with minimum health and safety standards. Under Part 2, in England at least, there are further mandatory conditions, as many of you will know, restricting the use of sleeping accommodation in an HMO according to the size of the room and its occupation, whether that's by persons under the age of 10, over the age of 10, or persons, one person under the age of 10 and one over, for example. Others requiring the license holder to declare to the local authority rooms that are less than 4.64 meters squared. So that's the minimum size for a room occupied by one individual. And to remedy any breach of the previous requirement, which restricts the use of sleeping accommodation according to size and occupation. So that the local housing authority has the ability, where, for example, a license is granted and the sleeping accommodation provisions are not at that time complied with, enables the local authority to give the license holder a period of time in which to remedy that breach, and may impose conditions, or must rather impose conditions to that effect. And requiring the license holder to comply with any local housing authority scheme for the storage and the collection of household waste, pending its collection by the waste collection for services. And then under Part 3, there is a further mandatory condition that requires license holders to demand references from prospective occupants. So they, as I say, are the mandatory conditions, heavily paraphrased, broadly concerned, as you'll see at the top part of the slide, with health and safety conditions, but additionally in respect of Part 2, concerned with avoiding overcrowding of HMOs and avoiding the use of very small rooms, which are considered hazardous to occupation because of their size. And in respect of Part 3, ensuring that the occupants of a Part 3 house have some security and protection by reason of having a written tenancy, or by reason of having a tenancy or license agreement. Sorry, that's in respect of both Parts 2 and 3. So let's take a look now at the more vexed question of discretionary license conditions. And under sections 67 and 90, the local housing authority has a discretion to include license conditions, but the discretion under Part 2 differs materially from that under Part 3. What, I hear you ask, is the critical distinction? Well, it's highlighted if we take a look at and contrast sections 67 1 and 91 of the 2004 Act. And bear with me while I just pull this up on the screen. It may help if you have these in front of you while I'm talking about them. So under Part 2, which of course deals with HMOs, 67 confers the discretion on local housing authorities. And as you'll see under subsection 1, provides that a license may include such conditions as the local housing authority consider appropriate for regulating all or any of the following. That is, the management, use and occupation of the house concerned. We'll come back to that in a moment. But then additionally, and note this, its condition and contents. When we turn, however, to section 90 of the 2004 Act, which concerns, or rather confers, the discretion on local authorities for the purposes of Part 3, the provision is notably different. So A license may include such conditions as the local housing authority considers appropriate for regulating the management, use or occupation of the house concerned. Note that the words and its condition and contents are omitted. Now we'll take a look at that distinction in a moment when we consider the case of Brown and Heinberg Borough Council. But before we take a look at that, please note under sections 67(2) and 92, local housing authorities have the discretion to include as appropriate, first of all, conditions restricting or prohibiting the use or occupation of parts of a house, and secondly, conditions requiring reasonable and practicable steps to be taken to prevent or reduce antisocial behaviour by occupiers or visitors. Under section 67(2), which you haven't got on the screen at the moment, local housing authorities also have the power to include conditions which require the licence holder to provide and maintain, and indeed undertake works, any such works as are needed to provide the facilities and equipment needed to meet prescribed standards for the occupation of an HMO by a maximum number of persons. And those prescribed standards relate, for example, to fire safety, to cooking facilities, to bathroom facilities, etc. But also in respect of attending training in relation to, and I quote, any applicable code of practice under section 233. And there are codes of practice that have been issued under section 233, but they are exclusively concerned with the provision and management of student accommodation. In the rare circumstance that you need to consider those, take a look at the codes issued under section 233. So I mentioned the case, the authoritative case of Brown and Heinberg Borough Council, which was a 2018 case taken to the Court of Appeal. And the essential facts, bear with me while I pull that slide up. The essential facts were these: that Heinberg and those from Heinberg who are present today, hello, had granted a Part 3 licence, which had included conditions requiring the installation of carbon monoxide monitor and the maintenance of electrical installations to a minimum standard. And Mr. Brown had argued before the first tier tribunal that Heinberg had no power to include those conditions, or indeed any conditions that would have required him as the licence holder to upgrade the property or to provide new facilities and equipment. And his argument was that essentially those conditions requiring, for example, the installation of a carbon monoxide monitor or the maintenance of electrical installations required him to do so. Note that the law has changed since the decision in Brown and Heinberg, such that there are, of course, as we saw now, provisions relating to carbon monoxide and the maintenance of electrical installations, in particular in England. So the first tier tribunal held in that case that the conditions that had been imposed did go beyond the power that was conferred by section 90, which were limited to regulating the management, use or occupation of the house, but not its content, its condition and contents. And on appeal to the upper tribunal by Heinberg, the FTT decision was overturned, the upper tribunal construing section 90 a lot more broadly than the first tier tribunal had done, and it reinstated the local authority's conditions. That appeal was then taken further, from which we get the Court of Appeal's judgment. And in a nutshell, the Court of Appeal found as follows: that unlike section 67 subsection 1, section 90 subsection 1 did not confer a power on the local authority to include licence conditions that regulated the conditions or content of the house, nor indeed what facilities and equipment should be made available in it. And you need to look at paragraphs 48 to 50 of the decision for the crux of that judgment. It went further and held that the purpose of section 90 subsection 1 was to enable local housing authorities to address the reasons for the designation in the first place. So, for example, to address issues of low housing demand or antisocial behaviour, and that there was a necessary link between the conditions for making a designation and the power to impose licence conditions under section 90 subsection 1, although it did go on to say that a direct and unequivocal link between those two conditions, sets of conditions, was not necessary. Take a look at paragraphs 57 to 57 apparently, but if you go to paragraph 57, you'll be able to see the crux of that decision. It held further that subsection 5 in section 90 emphasised the primacy of part 1 for addressing housing hazards. So, for example, where a local authority was concerned with the condition of a house because it was hazardous, then as far as part 3 was concerned, the primacy in addressing those hazards lay with part 1, and the local authority should, broadly speaking, use its powers under part 1 to address those concerns. So that was the decision in Brown and Heinberg, which, of course, as you would expect, caused a deal of consternation for local housing authorities following the decision in 2018. So the questions that arose, given the apparent restriction on the local authority's power, concerned, well, what exactly, therefore, did the management, use, and occupation of the property entail? Well, some light on this is cast in the Court of Appeal's judgment in Brown, in particular in the judgment given by Lord Justice Underhill at paragraph 85. Lord Justice Underhill did recognise that the terms use and occupation and management would overlap in certain factual circumstances, but gave some hint at what management might entail. So as far as he was concerned, management related to operational matters, in other words, what actually happens at and to the property. And that would include, for example, conditions to ensure that rubbish was properly binned for collection, conditions that ensured that fire escapes were kept clear, and possibly, although he said he wouldn't decide the issue, conditions for ensuring that routine non-structural maintenance, such as replacing broken glass in a broken window rather than leaving it boarded up for a long time, that they might well fall within the concept of management, but he expressed no final view on that. It's become clear since the decision in Brown, however, that management is also broad enough to include conditions that would require a licence holder to undertake certain training, for example, in relation to tenancy management. We'll take a look in a moment at the case of Berg and Burnley, which affirmed that proposition. As for use and occupation, well, arguably those terms are more straightforward to construe. It's quite clear from the 2004 Act itself that it would include conditions that restrict or prohibit the use or occupation of certain parts of the house. That's expressly provided for. Query, therefore, whether the local housing authority has the discretion to, under Part 3, to impose conditions that in the way that is done mandatorily under Part 2, restrict the use of certain bedrooms by reference to size, maximum occupation levels. And my view is that it seems quite clear to me that local authorities can do that, where, for example, they have a concern that residential accommodation in the designated area is being overcrowded, or that inappropriate room sizes are being used to accommodate too many people, for example. So it seems to me that where the local housing authority has minimum room size requirements, then in order to ensure that there is no overoccupation, overcrowding, that it would be legitimate, depending on the facts, to impose such conditions. Let's take a quick look at the Berg and Burnley decision before I look at some of the questions that have been put to me. So Berg and Burnley was a relatively recent decision by the upper tribunal, which concerns training requirements that were imposed by Burnley on the license holder. So essential facts were that, like Section 67, Section 90 empowers local housing authorities, as we've seen, to include such conditions in licenses as they consider appropriate for regulating the management, use, or occupation of the house concerned. And on an appeal by Berg, the first tier tribunal had varied conditions that were included in his license, including one that required him to attend one landlord development day covering how to manage tenancies and any additional property management training courses that the local housing authority from time to time requires to be undertaken. And he appealed that decision, arguing that the condition was contrary to the decision in Brown and Heinberg. The upper tribunal, as you'll see, dismissed that appeal, holding that so long as a condition related to the management, use, or occupation of a Part 3 house, then it was permissible. Paragraph 25 of the judgment deals with that. And in paragraph 26, it was held explicitly that on that basis, the training condition that was sought to be imposed by Burnley in that case was perfectly in order. The fact that Section 67, subsection 2F, under Part 2 expressly empowered the local housing authority to include conditions requiring a license holder or manager to attend a training course, and that provision was missing from Section 90, did not mean that local housing authorities could not impose a training a training course condition under Part 3, because the breadth of the permissive wording in Section 90 was wide enough to encompass it. And in the circumstances of that particular case, the condition was not disproportionate. So it appears entirely legitimate where, for example, a local housing authority has concerns about the management of a property, or the license holders or the manager's ability, to manage the property, legitimate to impose certain training conditions. Well, it's very close to 12 o'clock, and I'm conscious that the 1 hour for this webinar has very nearly expired. So let me take a brief look at some of the questions that I have for this particular webinar. I'll try and get through as many of them as I can. So how can a local housing authority bind a third party to license conditions if they are not the license holder? Well, that's a very good question, because if you take a look at sections 67, subsection 5, and section 90, I think it's subsection 6, a license cannot include conditions that impose restrictions or obligations on a person other than the license holder, unless that person has consented to the imposition of the restriction or obligation. So there is plainly a need for the third party to provide their consent to the condition that is imposed. But additionally, if you take a look at Schedule 5, you'll see that where the local authority proposes to include conditions in a license, which would have the effect of binding a third party, they need to follow the Schedule 5 procedure and therefore serve on the third party notice of the license that it intends to grant, and consider any representations that are made during the consultation period, and then make a decision. But critically, it would seem, because of the provisions I've just discussed, Section 67 and Section 90, subsections 5 and 6 respectively, that the local authority would probably need the express consent of that third party, not just silence from them, in order for them to be bound. So that written consent is probably what's also required. So that's the way in which, broadly speaking, you would go about it. Can license conditions be included to require the license holder to undertake fire safety works? Under Part 2, plainly yes, because that concerns the condition, contents, facilities, and equipment that's available, and indeed there are mandatory conditions. There are mandatory conditions that deal with these particular issues. Under Part 3, the position is more difficult, and the answer is no, generally, save where the condition is mandatory. Because the power, as we've seen under Section 90, subsection 3, rather, the power under Section 90 to include conditions is not broad enough to include those relating to a condition, content, facilities, or equipment. There is a power under Section 90, subsection 3, to make regulations that prescribe standards for Part 3 houses, and for the local authority to therefore impose conditions that require the license holder to meet those standards in the same way as we saw under Part 2, but that power hasn't been exercised. So the power to include license conditions requiring facilities and equipment to be provided to meet such standards is, at the moment at least, redundant. How can a local housing authority amend its license conditions? Well, for that, very briefly, it would have to go through the process of variation in respect of licenses that have already been granted. In respect of those that haven't, it's very easy. But as you'll recall, the circumstances in which it can do that are limited. So take a look at the variation slides and provisions. And then lastly, should a local housing authority use just one general set of license conditions, or should it tailor them to the applicant or the property? The answer to that, I would suggest, is a combination of both. It's very sensible, and you have to have a general set of license conditions in any event, because every license has to include the mandatory conditions that are prescribed by Schedule 4. In addition to that, the local authority will no doubt have its own conditions, whether under Part 2 or Part 3, that in the exercise of its statutory discretion it wants to include. And in addition to that, it can, of course, include specific conditions that are tailored to the applicant or the property. So, for example, as in Berg and Burnley, I can't recall whether the training condition was a general condition that was required, but there seems to me no difficulty where a local authority has concerns about a license holder's ability to manage a property to require the license holder to attend a training course, for example, that is laid on by the local authority. And that needn't be a general condition. It could simply be a condition that is tailored to the particular applicant and license holder. So I hope that today has given you a good grounding in the characteristics of licenses under Parts 2 and Part 3, and indeed some knowledge of the scope of the local housing authority's power to include conditions in a license. These slides will be sent out as a PDF after the webinar. There are a number of typos that, as you'll have seen, I need to correct before we do so, but also the webinar itself will be available in due course on the website. So it only remains for me to say thank you very much for attending today. This, as I say, is the third in a 4-series set. So next week will be the last of them for July. Next week, we will take a look at enforcement of the 2004 Act's enforcement provisions. So we'll take a look at the enforcement provisions in greater detail, prosecutions, financial penalties, etc. And hopefully then that will give you a good grounding in local authorities' powers to enforce the standards set by Parts 2 and 3. So thank you once again for joining me. That is the end of this webinar, and I wish you a very good afternoon. Thank you very much, and goodbye.